Thanks for coming. We usually do lunch and learns on big topics, but what we're doing today because of COVID and that kind of thing is our second webinar instead of lunch and learns. So what I'm going to ask you to do, if you can, if you haven't already done it, is to mute your audio. If you have a question, no problem, unmute your audio. And if you can't unmute it for some reason, wave your hand and I'll try to figure it out for you. If you have a question, just unmute your audio. You can interrupt me. I'm happy to answer questions, that kind of thing. I can tell you that I had big plans for this house we're at right now to be very quiet, just us, but it didn't work out that way. So you're going to see I have two big golden doodles walking around. We have some workers that happened to show up exactly about 20, 30 minutes ago. And we have an elevator and it turned out it broke. So someone is actually stuck in an elevator. So we're having some issues here. My wife is dealing with that. So there might be some background noise, but we'll do the best we can. All right. So again, thank you for being here. We'll have more people showing up. So the topic for today is a perfect storm for advanced estate planning. Also, if you have any questions, other than unmuting yourself, you can also hit the chat button and you can type in your chat. Either I will see it or my associate Allison will see it and she'll get it to me. Either way is okay with me. So I hope everybody's doing well in these difficult COVID times that we're all in. Let's see what else we got here. Okay. I was thinking about this topic and the reason why it's the perfect storm right now. We were already thinking about doing advanced planning. And the reason was that under the 2012 Tax Act, we went to $5 million estate, the applicable exclusion amount, the gift and estate tax exemption and GST exemption, $5 million index for inflation. And then the 2017 Act, we doubled it to $10 million index for inflation, but just temporarily. So it's going to come back on January 1, 2026. To $5 million index for inflation. So it's an extra $5 million per person, per giver, per taxpayer, that is temporary. So we're already thinking about how we're going to use this $5 million so we don't lose it. Already on our minds. But then what happens during this year is we hit incredibly, historically low interest rates, which make doing the planning way more beneficial. We can do more things more effectively. We also we had a serious market crash, which lowered asset values. And then now a lot of those values have come back. Some of them have not. But we also have volatility. Volatility in this kind of market leads to, in general, not every asset, but in general, lower asset values, especially hard to value assets like businesses and things like that. That are not marketable and easily valued. So the perfect storm is the combination of all of these factors together. We already do planning anyway. Now the interest rates are incredibly low. The valuations on a lot of assets are low. And now you have one more added component. As anyone keeps up with politics, we have gone from Republicans, the high probability was going to be another continuing stalemate, one party controlling one house of Congress, the other party controlling the other, presidency. It was leaning Republican, but you don't know, hope for, I don't want to talk about politics, but whatever you're thinking. Now, the trend is very different in the last few weeks. The trend is the Democrats may, in fact, it was a possibility, but now it's the highest probability today. It may not be the highest probability 2 weeks from now, but today it's the highest probability. The Democrats are taking the whole thing. And if they take the House and the Senate and the presidency, then the analysis goes from, yeah, I think I'm going to get to my planning, to all of a sudden, there's more immediacy to getting it done. Why? Because if they take over both houses of Congress and the presidency, as of November of this year, January this year, whatever, next year, then all of a sudden, everything's open. That means tax rates could go up on the wealth transfer taxes, the gift, estate, and GST taxes. They could make significant changes to the income tax rates for ordinary income and capital gain. They could mess with step up an income tax basis on the income tax side when someone dies. And when I say, I always want to correct this. When I say step up an income tax basis, what I really mean is in the financial industry, mark to market. So it changes the asset, the basis in assets, any capital gain assets that you would sell. If you sold them, it would be capital gain or capital loss. It changes the basis to determine gain or loss to date of death value, up or down, whatever. It's mark to market, whatever that date of death value is. All these rules are in flux if the Democrats take over. As you've seen, we have had a massive increase in debt. And with massive increase in debt, they're going to have to raise funds to start paying for some of the stuff. And of course, the Democrats want to be more socially conscious, which costs money. So there's going to be a huge pressure to raise taxes. Now, to me, there's always a bottom, how far they can go. So for example, on the state and gift tax side, on the exempt side, we predicted that the most highly likelihood before the Democrats of this trend was probably going to be keeping the exemption we have now in 2017 Tax Act, the 10 million X for inflation, probably making it permanent. Republicans would play a big game by getting rid of the estate tax. They probably weren't going to do it. But now it looks like the opposite, which was if Democrats take over in our analysis, if Democrats take over everything, then the best we can hope for on the estate tax side and the wealth transfer tax side is to keep these figures until 2006. And if there is a big deal to be made, a grand bargain, the Republicans, the Democrats may give up and continue the 2017 rules for some limited period of time. If there's no grand bargain, it's highly likely we're going back to the 2012 rules of 5 million X for inflation. And there's a possibility of two things. One, it goes back before it's expected to today, 2026. It may go back within a year. And it may go even further. And by further, I think there's a bottom as to how far it will go. And I think the furthest it will go, it's not a guarantee, but my thought is the 2009 figure, which is $3.5 million. That was the exempt amount that most estate planners believed was the right answer, was the logical answer. When they came up with 5 million and blew most of us away when they said $5 million in 2012. So, and you say, well, if it's all Democrat, they may go below $3.5 million exempt amount. But I think there's a bottom. I could be wrong. I think there's a bottom. The reason is because people in Congress have to live with these rules also. These taxes affect them also. So they're not going to want to slam dunk their own families as well. So I think the highest likelihood of the worst case scenario is $3.5 million exemption. You also have portability, which allows you, a married couple, to use both exemptions after the first spouse dies, following the estate tax return and getting the carryover of that first spouse exemption, which means for a single person, I'm thinking highest probability of worst case scenario, $3.5 million for a single person, $7 million for a married couple. I'm thinking worst case scenario, if the Democrats take over everything. So that lays the groundwork. We have the lowest interest rates we've ever had, and I'll tell you about those in a second. We have volatile and somewhat lower valuations, and we have higher taxes on the horizon. The combination of all those factors just changes this whole world and pushes those that are wealthier to do planning and do it sooner than they would have done it otherwise. So let's talk about what these interest rates actually are. They are unbelievable in my mind. When I got my first house in the early 90s, the mortgage rates were about 9, I think our first mortgage about 9 3/8, 9 3/4, something like that. They're now below 3%. It is just mind-boggling how low these interest rates are. And we'll go over one thing. So the rates are today, there's two types of interest rates that matter in this world of estate tax planning. There's the applicable federal rates. That is for it's basically under IRC section 7872. It says if your loan interest is at least this rate or higher, then you're not going to have this below market interest rate penalty, basically, which causes income tax issues and gift tax issues. So as long as you use that rate, you're using an appropriate rate. So what is that rate? The AFR rate is a short-term rate, applicable federal rate. Short-term rate, loans up to 3 years. Mid-term rate, 3 to 9 years. Long-term rate, over 9 years. The rates in August, the rates come out a couple weeks before the next month, because it changes every month. And the rate you use is month of the transaction. So in August, the short-term rate is 0.17%. The midterm rate, 0.41%. And long-term rate, 1.12%. These rates are close to zero. The other type of rate is called the Section 7520 rate. And that is used for particular statutory transactions, such as GRATs, which we'll talk about, or CLATs that we'll talk about. And again, I'm sorry about that noise on the side. We'll do the best we can. That rate, the 7520 rate, is 0.4%. And I'm going to, just so you know, if anyone cares, I'm going to put up on the screen the slides, but I just want to get this first part going here. The 7520 rate is 0.4%. For the first time ever, the 7520 rate was actually less than the midterm rate, which is odd. It is the 7520 rate is actually 120%, 20% higher than the midterm rate. And it's rounded to the closest to 0.2. In this case, it actually rounded down. Even though it's 20% higher, rounded down to 0.4. So we're in very odd times indeed. And that interest rate, whether it's the AFR rate or the 7520 rate, is what we call the hurdle rate. The hurdle rate is when you do one of these wealth shifting strategies that we're going to talk about. All you got to do is beat that hurdle rate. All the earnings on what you transfer, any of the assets you're dealing with, any of the earnings over and above the hurdle rate are a win. That's what you're shifting out of the estate for estate tax purposes, gift tax purposes. Another aspect about the hurdle rate, it's not, if you're doing the transaction to an individual, it's the actual hurdle rate. Sorry about all that noise. If it's going to what's called a Grantor Trust, hopefully y'all can hear me. This is great. It's not just the interest rate as a hurdle rate. It's the pre-tax rate of return on a Grantor Trust. Why? Because we'll talk about it. But when you use a Grantor Trust, the creator, the giver, your client, or you, are the taxpayer. So the growth on a non-tax basis, as if you're not paying any tax in this trust, as long as it grows more than the hurdle rate, you're winning. Because you're shifting all earnings over and above the growth and the income over and above the hurdle rate on a pre-tax basis, effectively. So it is pretty phenomenal. And as I said in our newsletter series on this topic, which kind of came up with when I was writing it, I said, here's my quote: if you not expect to exceed these historically low hurdle rates, you need a new investment advisor. The rates are so low, you could buy bonds. I mean, they're so low, it is unbelievable. Because this rate is based on the government's ability to borrow, which is the most powerful country in the world, most economically significant country in the world, and it borrows at really low rates, or lends at really low rates to banks and such. So, in any case, let me go ahead and share. That's our beginning. All right. So I'm going to share. Hopefully, everybody can see this. We went over this one already. Let's see. Got that. So, just to repeat, the goal of the wealth transfer planning is to move assets on a relatively low valuation basis and have them explode outside and grow outside the estate tax. And having low values, I didn't mention this before. One of the ways that we could do this before the low rates just kind of hype up the rate of return. If you have a hard to value asset, subject to valuation discounts, like let's say it was a 1% interest in a closely held business. And if you sold the entire business, let's just use a round number for just ease, it was worth $1 million. And 1% is worth $10,000. But it's not, you can't trade on a New York Stock Exchange or NASDAQ. There's no easy market, it's non-marketable. And 1% doesn't control. So that $10,000 is, you couldn't actually sell it to anyone for $10,000. They might buy it for $6,000, a 40% discount. So on a estate tax perspective, when you're doing these transfers, if you can get values depressed, either because they're marketable and depressed or because they're subject to discounts, you move them out of the system at a depressed value and they kind of explode on the other side. That existed before, but now we're doing with a tiny interest rate, which makes it even more valuable. All right. Okay, so what are we talking about? What are the benefits of doing this planning? The one we're going to talk about today is the ability to reduce taxes, primarily wealth transfer taxes. But there are way more benefits that you can achieve doing these strategies. One, and this is a big one, and that is asset protection. Assets that you move away from you in the proper way cannot be attacked by unwanted outsiders. You can lock in control, either present future control of assets, prior to your death if you do a gifting type of transaction or a loan transaction. And you're maximizing, you can kind of hype up the benefits, maximize the benefits of giving to charity. So you can get your family more benefit by giving to charity. You can take, you may be able to take advantage of the kids' lower marginal income tax rates. You might be able to avoid state income tax. That usually makes sense when you, the client, are already in the, your family's kind of already in the highest estate, or you, the person doing the transfer, they're already in the highest income tax bracket. Because to do this planning or avoiding state income taxes, you are kind of accepting you're paying the highest income tax bracket, but you want to avoid the state level tax. And then there are strategies to maximize the step up or mark to market in the income tax basis. And the kinds of things that we can do with that. Hang on one second here. Just had a couple thoughts on that last one, so we didn't pass it. One is ensuring that low basis assets are subject to the estate tax system when someone dies. All they get is a step up. So you can manipulate how the assets are owned to get you there. There's a possibility of doing upstream step up in basis where you get the assets subject to estate tax in another family member's estate. Example, your parents' estate. Or your parents' estate, to get the step up and the assets come back down if you do it the right way. And lastly, there's the elective community property trusts. They have those in Alaska and Tennessee. If you have a high appreciated portfolio of stocks or a high appreciated real estate or something, you might be able to get a full step up in basis for a husband and wife when one of the spouses passes away. So there's different ways you can do that to manipulate that. I wanted to give a little flavor. There's other benefits you can achieve, but the one we're talking about today is primarily the wealth transfer tax, avoiding that wealth transfer tax, because that is the pretty much the high, well, it used to be the highest rate, now income tax rates could be higher. Right. Now, let's get to the important questions. What level of wealth should you have before undertaking this advanced planning? And this is the number one question. What level of wealth do you need? The question is, should you do it? Because whatever you do will reduce your access and control to these assets to some extent. It may not be a lot because we can modify it, but you're doing something. people are going to feel better if all their assets are in their own name. So to do this, you're doing something that will take away that 100% access, 100% control. So who should do this? So the first thing is, what level of wealth? So I've broken it up into different levels of wealth. Number one, the ultra wealthy individuals and couples. Those are people that will absolutely be over the current, the exclusion amounts. The basic exclusion amount, applicable exclusion amount. Just so you know, the basic exclusion amount, that's a single person's exclusion amount. The applicable exclusion amount is after the first spouse dies, they roll over the other one, port it over, now have both of them, that's the AEA. So it's about 11.6 million, or for a married couple, 23.2 million thereabout, and going up a little bit every year. If the family is going to be, the clients are going to be well over those numbers, the answer is just do the planning. Just when and what, but you should do it. There's really no question about it. The next one is you're wealthy. Not ultra wealthy, but you're wealthy. What does that mean? You're probably going to have more wealth than we're expected to go back to in 2026 or possibly before. That's 6.5 million for an individual in 2026, 13 million for a couple. That's an approximate number. If you think you're going to be that or more, this is planning that you should definitely consider, and you may really want to do it depending on your situation. Not absolute, but definitely something to consider. Then you get to the mass affluent individual and couples, and those are individuals and couples that will be over what I would call the lowest likely scenario, which is a 3.5 million to 7 million for a married couple. And those people should absolutely consider it, and then they should act depending on their circumstances and what they think or actually see about what happens in the elections that are coming up. So if the Democrats don't take over fully, then these people are probably not going to be at too much risk. But if Democrats take over fully, they're at risk. The last one is the majority of our society that are not part of the mass affluent, and those people are probably fine. They don't need to do any of this planning. However, they need to have their eyes open if the Democrats do take over everything, both houses of Congress and the presidency. All bets are off. Even what I said was highly likely low is not a guarantee. Just need to be aware that it could get worse. They need to keep their eyes open of possible planning in the future, but probably are going to be okay. Now the question is, to what extent, if you fit one of those criteria, and you should consider it, to what extent should you actually do it? This is question number 2 of significance. And that is, you should not do it in a manner that should affect your financial security. The key, you need to feel financially secure when this planning is completed. And from our perspective, that should not be a problem if you do 2 things. Number 1, you do not gift anything that you're relying upon for your ongoing support. And 2, you understand, at least you'd use a law firm like us, you understand and you do the planning inside these structures, whatever we're going to set up, so that there's sufficient, what I call release valves, which provide practical access and control over your assets that you're transferring. So you don't give away anything you're going to really need, and you make sure you do it in a very flexible way, whatever you do, so that you can get indirect access and control over it if need be down the road. What happened in 2012, more gifting happened in 2012 than has happened in the history of Earth. And that was when the exemption went from $5 million, it was about to go down at the end of 2010 Tax Act, it was about to go down to $1 million on January 1, 2012. And everyone started gifting. Why? Because if you were wealthier, there was husband and wife, $4 million of exemption, you would use it or lose it. If you're a single person, $4 million, use it or lose it. So a lot of people waited to the last very minute because they really didn't want to do it. And then they did it. And then they ended up, right after the first of the year, in 2012, I believe it was signed maybe January 3rd, something like that, the 2012 Tax Act, which made it permanent, $5 million exemption. So there was all these seminars, all these people freaking out. They wanted to undo their gifts. We had 0 undo their gifts. Why? because we never had anyone gift away something they couldn't afford to gift. And number two, they retained practical asset access and control of the assets so that they never felt financially insecure. That's the key. All right. Now, you at this point, you figured out, okay, do I have enough money? Actually, let me go back. I had a question before that was, let's see, hang on a second. Garrett Alton asked a very good question. For those that are financial professionals, trusted advisors, and they deal with lots of clients, what kind of questions could they ask their clients to get them to take a deeper dive into this topic? And I would say there are two things. Number one, you go with the whole criteria we just talked about. Who should be doing this? What level of wealth are they? So if they have enough wealth where this is a serious issue, they need to be talking about it, at least considering it. Number two, a good loaded question is, are you concerned about higher taxation if the Democrats take over both houses of Congress and the presidency? And my guess is that most people have a position. They're either concerned or they're not. So I think that's food for thought. Hopefully that helps a little bit. Now let's talk about if you have enough wealth, your client has enough wealth to do this, consider it. Number two, they're comfortable not doing too much. There is plenty to do. That there is a lot of leeway there where there's something they can play as they can mess with, do transactions with without feeling financially insecure. Now the question is, what should you do? We go from easy to more complex. So let's start with the really easy. So the first one is tax-free gifting. Hang on one second. Tax-free gifting. We've had tax-free gifting. I've been doing this since 1987. We've had this tax-free gifting well before I ever started becoming a lawyer. It's simple. It's very effective. And a lot of times what we'll do is if someone's borderline on being in a state tax situation, we'll use tax-free gifting, just kind of like getting money off the top to keep their estate either at a low tax rate or no estate tax situation. What are the tax-free gifts? You probably already know this anyway. The annual gift tax exclusion. So per giver, they can give anyone or everyone up to $15,000 per person per year, as long as considered present interest gifts, which means they can actually use those funds or assets, whatever it is, in a qualified manner. And that, just so you know, it's not actually $15,000. That's what the number is this year. It's actually $10,000 indexed for inflation. Goes up $1,000 increments. So this may change in the next year or two to $16,000. Every so many years it'll go up in $1,000 increments. And we can, on the more advanced planning, you set up what I call family gifting trusts. You have many beneficiaries, all the whole family's in there, and you can kind of use these beneficiaries to get the $15,000 per person per year into the trust for free. And if you're married, you can do what's called gift splitting, and one spouse can get in $30,000 per beneficiary per year. And with large families, as you can see, you can move a lot of assets on a totally free basis. You don't use up any of your applicable exclusion amount or base exclusion amount. Again, also you have spouses and charitable organizations and unlimited tuition, medical expenses, as long as it's paid to the provider. Those are the freebies. We all know about those. The taxable gifts, you can use up, so you have the basic exclusion amount. We keep changing the name on me. Started out unified credit, state tax equivalent. Now it's called the basic exclusion amount. So if I say it wrong, sorry about that. I got a lot of words in my head. It's supposed to drop in January 1, 2026, and that may happen earlier. But you have that exemption, that 10 million index for inflation, that you can use any of it you want today, as long as it's there. You can use it. Now, if it drops, it's gone. But if you use it, you're good to go. And we used to have a concern about recapture, different names for it. Recapture theory would have been that you would have gifted, let's say, the full base exclusion amount today, and then when you died, the exemption actually was lower, and they would have done the calculation to kind of recapture that benefit, and you would have to pay estate tax on it effectively. But the IRS came out and gave us a very pro-taxpayer position, which is we don't have to worry about the recapture. If you've got two things. If you use the exemption, it is used and is effectively used. Number two, with portability, if a spouse dies and transfers over their exemption on paper by filing a timely estate tax return, that number is also frozen and locked in. It will not get recaptured if the number goes down. So those are two good things. So you could do simple and straight up outright gift. We don't recommend it. It's possible. It can be good in some situations, but we have found there's other ways you can do this. Although, let me back up. Taxable gifting does have its place and may be beneficial depending on the situation. Now let's go to the ones a bit more interesting. And that is taking advantage of low interest loans. And if it's because it's a loan and not a statutory approved transaction, statutory approved transactions primarily use the 75/20 rate. Today there's at 0.4%, but normally is 20% higher than the midterm rate of the AFR midterm rate. With normal loans, sales for promissory notes and the like, they're not statutory approved transactions, and therefore they use the government interest rates. So as we talked about, the up to 3 years is short-term rate 0.17, midterm 0.41, long-term 1.12. Extremely, extremely low. The key is that is a bona fide loan, and you get to use for any legitimate purpose, but it has to be legitimate. So there has to be some ability to pay the money back, even if it's just with those funds. It has to look like it's a bona fide loan to be repaid, even if at some point it is not, and turn into a gift, which we'll talk about in a couple minutes here. You can use it for any legitimate purpose. You can use it to help a child buy a house. You can refinance their mortgage at a really low interest rates. You can help them buy a business, help fund their business, any non-marketable assets, buy land. You can, any investment that you would have bought, you can help your child buy it by loaning them the money. So let's say you were going to have an investment advisor invest your funds, and you believe there was a pretty good probability you were going to earn a decent rate of return. You could loan those funds to a child, for example, and your child could invest in that manner, and anything over and above the lender would get back your money at some point with the interest rate, this tiny, tiny interest rate, and the child who got these funds for the period of time would keep all of the earnings over and above that tiny interest rate. And the child, because they're now the taxpayer of those earnings, would pay income tax at their likely lower income tax rate. So doing loans can be very, very effective. So let's go through just a simple example. Simple example to a child. Parent loans $1 million to the child on August 2020 this month for a period of up to 9 years. The annual interest payments being made and then a balloon payment at the very end. So you maximize the amount of time that the child has the funds to invest. They're going to use, because it's between 3 and 9 years, they use the midterm rate, which is 0.4% if it's done in August. Now, August has unbelievably low rates, but we had incredibly low rates last month, and we'll probably have incredibly low rates next month. I do not believe interest rates are going to skyrocket anytime soon. It's at this point unlikely. For a couple of reasons. One being the government's debt is so massive. If the interest rate skyrocketed, it would put our country in serious turmoil, and the government's not going to want that to happen. So these rates, whether they're lower today, about the same, or a little bit higher, they're probably going to be in this range for a decent amount of time. So let's say that they use the midterm rate because it's less than 9-year notes. The child will pay $4,100 on $1 million loan annually. And let's say the child averages earnings 6% simple return. I don't like using simple returns. That's 6% on $1 million, not compounded. So it wouldn't be 6%, it'd be 1.6% times. So we're not doing compounding because that's more complicated math. I want to make it really, really simple just for the example. You're at 6% on $1 million every year. So the child gets $60,000, pays the parent $4,100 for the interest. The child keeps $55,900 annually during the term of this loan. free money. The child pays tax on the lower income tax rate. It's kind of a slam dunk. Let's go to another example and go one level of complexity up, but it just keeps getting better. Simple is really good. Simple is very good. But when you go a little bit more complex, sometimes you can get a lot more benefit. And this is one of those examples. So instead of doing a loan outright to your child, the one benefit of that is getting the child's income tax rate if that's something you really want to do. But on the wealth transfer tax side, this is a better way to go. You do a simple loan to a Grantor Trust. Our Grantor Trust is what we call a family gifting trust. That's the way we structure them. Our Grantor Trust means it is invisible for income tax purposes. And the grantor, the creator, the funder of this trust, the one who set it up, you, will be the income taxpayer on it as if that trust does not exist. And that enables you, because it is you for income tax purposes, you can deal with it. You can buy and sell from it, loan to it, borrow from it, lease to it, lease from it. You can transact with the trust and it has no income tax effect at all. As long as it's bona fide, full fair market value transfers, it should be fine. So let's, instead of giving the loan outright, we're going to give it to a trust. $1 million loan to the Grantor Trust. In that Grantor Trust, let's say we have the spouse as the primary beneficiary, we have the kids as secondary beneficiaries, and we can have the spouse be trustee if that's desired. So the spouse on the outside has access, indirect access and control through their spouse and other what we call release valves to get access to these assets if ever needed. But they're going to loan $1 million to this trust. Same facts as the other example. 9-year note, a note up to 9 years. They use the midterm rate, 0.41%. The annual interest will be $4,100. The 6%, $60,000, shifts $55,900. The same exact result as if it was outright, except for the last one. Except there's two other ones. One we told you before, because it's in trust, it hasn't actually gone anywhere yet. While we're shifting assets on paper, it really hasn't left indirect access and control from the giver. It's still there. We can still somehow get access and control over it, even though it's shifted away. If you give it to a child, in theory, it's kind of gone. You have a note, but it's kind of gone. You go to the trust, it really hasn't left yet, except on paper. That's one. Number two is that because it's a Grantor Trust, the income tax, the taxable income earned in the trust is taxed because it doesn't really exist for income tax purposes. It is taxed back to the creator funder, the grantor. And you might say, why would the grantor, want to pay income tax on earnings that you don't get? They're in the trust for the family. So why do I want to pay income tax on those earnings? A huge reason why. Because effectively, it's a free gift. So remember before you had free gifts, the annual exclusion gifts, $15,000 per person per year, tuition and medical expenses paid to the provider, outright to the spouse or certain qualified trust to the spouse, and to charity. Those are freebies. This is another effective, not technically, but effectively, practically, another free gift. Every year, you are paying the trust's income tax. Why? Because the law forces you to do it. Since the law forces you to do it, it's not a gift. But it's as if you put in the tax money trust and the trust paid its taxes, which means these funds get to grow on a pre-tax basis. Kind of hyperdrives the rate of return. As we talked about before, the hurdle rate isn't just the AFR rate or 7520 rate with the Grantor Trust. It's actually the pre-tax rate of return compared to the hurdle rate. So let's say that you're earning 6%. It's the full 6% that gets removed outside the 0.41. So the full $55,900 is out. The income taxes are not paid at that trust. Income taxes are paid from the grantor. So it hyperdrives, I don't know if it's the right words, but it really hyper benefits the planning to get that done with the Grantor Trust status. All right. And this is a big one, and I think a lot of people are going to end up here because it's relatively simple and relatively effective. And that is, what if, and this is a combination of a loan and gift. And the theory is, I just called it the convertible loan strategy. That may not be the proper wording. I just came up with it. A convertible loan is an actual thing. So it may not be the right words, but this is the way I kind of think about it. It is convertible into something else. For those that aren't sure, they really want to make a big gift. They're just not sure at this point. They're not sure they really need to. They're not sure if they can handle it financially. They don't know what the law is going to be. They're just not sure. They could go ahead and make a very large gift and do it in one of these strategies, either outright or depending on how you want it to end up, or in trust. I favor trust over outright. And it's a loan. And we go along and it's a loan. And these trusts, these loans are very flexible because you can always prepay the loans. You can end it like that if you wanted to, just pay the money off and you're done. If it turns out that the laws revert back to the 5 million next for inflation, or Democrats get in and you're afraid they're going to do it even faster or even do something worse, then in a very relatively quick period of time, the lender, you, can change that loan into a gift. So you just give up the right to receive the loan back, and all of a sudden you forgive the loan, and it is a gift, a taxable gift. So all of a sudden, without having to do a whole bunch of planning at the last minute, you can quickly just turn it from a loan into a gift. So that may be something a lot of people do. It pushes off the eventual actual transfer of real wealth until you feel like you really need to do it, but you go ahead and get a lot of the planning already done in advance. Another thing you can do with loans is almost all the loans out there today are at higher rates than exist today. Not all, but pretty much all of them are at higher rates. So you could refinance related party loans at lower rates if that's beneficial to you. And those loans could be to individuals, to trusts, to business entities, anything related party could be refinanced at these lower rates. And that could provide a significant benefit. Now we're going up a level. And that is grantor retained annuity trust. And you're going to see that we're going to have, there's two strategies that are similar to each other. One is statutorily approved, that is a GRAT, a grantor retained annuity trust. And one is not statutorily approved, but it is a tried and true strategy using existing law. There's just no statute that says you can do X. With a GRAT, there is a strategy that says you can do X. Let's see. Sorry about that. Just had to look at the message. All right. So the other one, so you compare a GRAT to a transfer. I'm sorry. Let's go through this real fast. It's going to be a sale to Grantor Trust. So it's either a GRAT, statutorily approved, or sale to Grantor Trust, similar but not statutorily approved. So what is a GRAT? And these might be complicated names. They're not that complicated to carry out if you know what you're doing. So a GRAT is a Grantor Trust. You'll pay the tax on it. You transfer assets to the specialized type of Grantor Trust. In return, the person putting the assets in retains a set annuity. It could be paid annual, semi-annual, monthly, whatever. A lot of times it's paid annually for a term of years. It can be as long as you want. The negative is, as long as you want, is that if you were to die during the term of the annuity term, it just didn't work for tax purposes. It's all included in your taxable estate, didn't work. And so oftentimes, GRATs are done for shorter terms of years because you want to not have the premature death risk that just makes it not worthwhile. At the end of the annuity term, so similar to interest payments or similar to payments on a loan, instead you are putting assets in and getting back an annuity, a set annuity term for a number of years. And at the end of the term, whatever is left, i.e. everything over and above, not the AFR rate, because it's a statutorily approved transaction, it's a 75/20 rate, which today is at 0.4%. Normally a higher rate, today it's actually about the same as the other rates. So 0.4%, That's your hurdle rate. Anything over the hurdle rate on a pre-tax basis is left in the trust, and that passes either outright to family or it stays in trust for family. So you put assets in, you retain the stream of payments called annuities at the end of the term. Whatever's left, the earnings over and above the hurdle rate are outside. They're out. Let's see. Now, what I would say is, say the most sophisticated, a common, for those that have enough stomach to deal with administrative burden. If usually this will happen if you have a really good CPA or have really good financial advisors or a good trust company. You'll need someone to do some administrative work with this thing because it takes ongoing maintenance. But it can be incredibly beneficial. It's not always. It's existed for a long time. It's just more powerful today because the hurdle rate is so much lower. So, and these are my terminology, at least the bifurcated part. That's the strategy isn't, but I think I came up with that. I don't know if that's the proper terminology or not, but I call it bifurcated rolling GRAT strategy. What is that? The bifurcated is, let's say you own a Home Depot stock, you own Apple stock, you own 8 stocks. In theory, and maybe some is real estate, whatever, different types of assets. And you say it might be some of these end up as winners over time, and some of them don't earn anything or they lose. So to get the most bang for the buck, you would set up a separate GRAT for each type of asset. So it's a single asset type of asset GRAT. And you would set it up normally for 2 or 3 years, or about 2 years, and you would get all your money back plus the 75-20 rate back over that 2-year period. If the asset grew faster than the 75-20 rate, that excess earnings is outside. When the annuities come back to you, you re-GRAT them into another GRAT, and you just keep this rolling. You put money in, money comes out, put it in a new GRAT. Money comes out, put it in a new GRAT. If the investment and all the winnings are sliced off and kept out, that's the win. That's the winner. That's the winnings. If the investment doesn't do well, which means it earns the 75-20 rate or less, you just get all your money back because your annuity is just going to pay you all your money back. There is no downside on loss other than opportunity cost. I could have done something else with the money and the inflexibility of being locked into the GRAT. But if you do a short-term GRAT, you're not locked in that long. So the rolling GRAT strategy is phenomenal if you have the stomach for the ongoing administration. If you have good professionals who are willing to do that for you, it can be an incredible strategy. It just now kind of zings more because the rates are so low. Let's see. What is the other that we're compare it to? Sale to defective or sales to defective, or sorry, it's the technical terminology that people use a lot is sale to defective Grantor Trust. To me, they're not defective. They're just Grantor Trust. Defective because the way the tax rules are worded, they're trying to push you into Grantor Trust status, and you're trying not to be in the old days, but now we actually want Grantor Trust status, so we're on purpose spelling the rules. That's why they call it defective. So I don't use that terminology, defective. We just say sales to keep doing it. Sales to Grantor Trusts. All right. So same idea. It's not statutorily approved. It's just tried and true. It's to a Grantor Trust. Instead of you put assets in, instead of getting back set annuity payments, which are locked. Those annuity payments are locked. You cannot change them. Versus this one, way more flexible. And you'll see which compare them. Flexibility is the key. Statutory, you get rid of certain risk, versus this is much more flexible. You set up a trust, you put money in, you're basically selling the money, this asset, to the trust in return for a promissory note. And in theory, you could just make a loan. It's just a loan to the trust. It's instead of, we talked about it before, it's a loan to the trust or sale to the trust. Here you're selling an asset to the trust. The goal is the assets you're transferring will grow significantly more than not the 75-20 rate for the GRAT, because that's statutory. This is non-statutory strategy, so it uses the AFR rate. Same idea. It's a Grantor Trust. You get back a promissory note. In this case, you don't get these annuity payments. You normally set it up where it's interest-only payments with a balloon, and you can always prepay the note whenever you want. Very, very flexible. You pay, because the Grantor Trust, just like the GRAT, you pay the income tax, so it's effectively a tax-free gift. All right, so now let's go to, we have a chart here which came up with comparing GRATs with sales to Grantor Trust. And there are some lawyers that love GRATs, and there are some lawyers that love sales to Grantor Trust. Traditionally, we have gone with sales to Grantor Trust because we love the flexibility. There are situations where we favor GRATs, but sales to Grantor Trust to us is kind of the fallback because we love the flexibility. Now that bifurcated type or rolling GRAT strategy is phenomenal in the right situation. You can handle the administration of that. So let's go through this. And let me give you the bottom line to keep this shorter and less technical. All right, the bottom line is GRATs are a sure thing. Technically, a sure thing. Statutorily approved. Why does that matter? Talk about it right here. Statutorily approved. See, I got GRATs, sale to Grantor Trust, which is better. So statutorily approved, GRATs are better. Why? They tell you exactly what you need to do, or pretty darn close to exactly what you need to do, and it has adjustment provisions, which comes down here to the second one. If you have hard to value assets, then the GRAT statutorily has a provision that allows you to modify the annuity payments so that there's no tax risk. It just kind of self-adjusts. That is not the case with a sale. However, there's a countervailing issue with even with hard to value assets with the GRAT. You may not have the valuation risk, but you have the risk that you don't have funds to pay the annuity. So you have to deal with that. How am I going to pay the annuity issue? So there's a pro and a con to that. But I would say these two things right here, risks that apply to sales because they're not statutory, and flexibility that the sales get. Those are the two overarching pros and cons. There are other ones, but those are the big ones. So the GRAT is a sure thing, especially that comes up with hard to value assets. Other than the only tax risk that you have outside of fraud or something like that, the only tax risk that you have of significance is premature death. So if you were to die during the annuity term, it doesn't work. So what do? You make a short term. Now, what some people do is they may make, hey, I love those interest rates. I want to lock those suckers in. I don't mind that it's inflexible and I can't change it. And sometimes they'll deal with that risk by buying a term life insurance policy. Hey, if I die, it doesn't work, I don't get any benefit, but I have a term life insurance policy and a trust to make up for it. And that isn't done, it's not done a lot, but that's the way to deal with that one GRAT risk. But most will deal with it by just making the term shorter. With the sale, you have, I would say, two tax risks. Number one, valuation and hard to value assets. Now, there's a way to deal with all these issues. The way you deal with the valuation of hard to value assets is, let me give you an example. You put a business interest or a real estate interest, something hard to value, it's not marketable. You just look at the stock exchange and see what the number is. So it's a form of art to get an appraisal versus you can look at the stock exchange to see it. Where it's a hard to value asset, if it's totally out of whack, you're at a risk without fixing it, without doing some adjustments to the documents. You are at a risk that the IRS will say, this is actually a failed GRAT, that somehow you've screwed up and you have taken advantage of the system. You have evaluation, penalty risk, evaluation risk if you're too aggressive. But there's two things you can do to deal with that. One, make sure you get a good appraisal. No messing around, get a good appraisal up front. Number two is you put in a formula on the transfer. So when you do the sale, you don't do it, I hereby give. you do it, there's different ways you can word it, but you do it based on valuations as finally determined for gift tax purposes. And if you use that language, and the case just came out recently where they didn't use that exact language and it was a disaster, at least you can determine it to be a disaster. As long as you use that, what will happen is that the IRS revalues and you lose that argument through court or whatever, settlement or whatever, it just adjusts the promissory note. Why? Because the value of what you sold was different. So you just adjust everything and it kind of works its way out. So if you proper planning up front, a little bit more complicated, but you do proper planning up front, you can usually mitigate that risk. We've never had a problem with it, but it is a risk. It is a real risk that you need to deal with. The second is on the sale for a promissory note, the note needs to be bona fide, which means that objective people should be able to look at this promissory note and say, this is commercially reasonable, this makes sense. Now, you're going to use a really low interest rate, but there needs to be security, there needs to be equity, there needs to be something that could repay this note other than what you just put in. There's not a legal requirement, but there's a fact circumstances test as to how to make this thing legitimate and bona fide. Now, there is a not statutory, but there's a rule of thumb that has been used for many years to be safe based on some stuff that the IRS put out years ago that wasn't, it was only, I think it was private letter rulings. I can't remember exactly what it was, don't hold me to it. I think it was to give private letter rulings, they wanted it to be a certain way. You need a 9-to-1 or better ratio of debt to equity. So if it was $1 million, you needed $100,000 of equity, $900,000 of debt. That was, if you had that, you felt pretty comfortable. If you don't have that, then you could do personal guarantees, a little bit more complicated. The issue you run up with is in dealing with that risk to make the note have some equity behind it other than what you just sold is the real downside to that. This is when you fix a problem, it may cause another one. So when you fix this problem, if you could use a trust that already has assets in it. You don't have to have the equity problem at all. Or you could do a seed gift to create this. Or you could have personal guarantees, but some kind of equity that you're putting at risk. If the investment doesn't do well, so if you have a high risk, high reward type asset where it could go to zero or explode, the GRAP might be better. The reason being, if it goes to zero or worse, it's going to take the equity back because you're on the hook for the whole promissory note. And if you end up with the value of what you gave worth way less than the note, you got to take other assets out of trust and give them back. So it actually ended up being a loser. Whereas a GRAP, it self-adjusts. And you just get your own money back if it's a loser. So that goes to show why if the investment could be a loser, the GRAP might be better. So we can the sale to Grantor Trust, much more flexible. It does have these risks, but it is much, much more flexible. Why is it more flexible? The note terms. The GRAT has a set annuity. There is no play. It is set in stone, and you got to deal with it. The promissory note, you can prepay it, you can refinance it, you can have interest only, pay the principal when you feel like it until the end. You got to all be paid out. You get all kinds of options. You get to make the note as long as it's bona fide, legitimate promissory note. You can do long-term trust planning, dynasty trust planning. You can't do that with the GRAT. So the GRAT is just all around less flexible. This is a little technical issue, but you cannot allocate generation skipping tax exemption effectively to a GRAT at the beginning. So if you did a GRAT, and a lot of times you zero out the GRAT so that the annuity is valued at pretty much the entire thing you put in. So if you put in $1 million into the GRAT, the value of the annuity based on the IRS tables and the interest rate, say 520 rate, that annuity is equal to, you get your $1 million back plus the 75/20 rate. The gift is basically zero, or you have a tiny gift if you want to do that for technical reasons. But basically you have a zero gift effectively. If you are allocating GST exemption so that you could have long-term trusts that are really great for asset protection purposes, you cannot allocate it when the trust is worth almost nothing. You have to wait until the grant is finished, the annuity payments are over, and then whatever's left, you can allocate to really do it right. With a promissory note, you don't have to do that. You just make sure whatever's in the trust you've gifted in or is already there, you've allocated to that, 100% GST exempt. The sale is not a gift transaction. There is no GST allocation needed, which means this whole trust is GST exempt, and it didn't take any GST exemption to allocate to this excess earnings on this sale. So it's way better for long-term trust planning. And if you were to deal with us, we're a huge advocate of long-term or dynasty trust. Huge, huge. So if you want to maximize those long-term trusts and getting things long-term trust, the sale is a way better way to go. So we're almost done here. So we go through that. We're not going to go through that. So the sale versus grant, great. One or the other or a combo could be great. So you have loans of some type. You have loans and or gifts of some type. You have grants. You have sale to Grantor Trust. And the last one we'll go over quickly is charitable lead annuity trusts. So charitable lead annuity trusts been around for a long time. They're like grants. They're statutorily approved. They're like grants. The difference is instead of the annuity coming back to you, the remainder going to family or loved ones. The annuity goes to charitable organization, and the remainder goes to loved ones. So the remainder is the same. This annuity, though, goes to charity. And the charity can be a family charitable foundation. It can be a donor advised fund, a supporting organization, and potentially a private foundation. Now there's some, it's a little bit more complicated. You gotta cross these I's and how you do all this stuff. But you can keep the wealth in the family's control for charitable giving, taking advantage of this. And charitable giving can have significant income tax benefits. So what you're really doing with the CLAT and other charitable giving is you want to take care, you do like charity, you want to take care of charity, but you're going to leverage what you're giving to charity to leverage that giving to get more benefit, and especially low interest rates, more benefit to the family. So it can be very beneficial. It's a lot more technical rules and different ways you can structure it, makes it more complicated, but it can be extremely beneficial for those that like charity as well as want to give to their family. All right. Do this. All right. Hopefully most of y'all are still here. I didn't see you for the whole time. So thank you very much for coming. Alice, do you know if there's any questions that anyone had?
Hey, Richard, I don't see anything in the chat box. Is there anything anyone would like to raise now?
Is there any questions that y'all have? Just unmute yourself or hit in the chat. I'll give you about 15, 30. If you raise your hand, I'll make sure I wait. No, we're good? We're good? Well, hopefully you liked the webinar. It's not, are you raising your hand, Kenneth, or are you just moving your arm? You're good, okay, good. Just want to make sure. All right, so sorry to provide you lunch today for our Lunch and Learn, but thank you for coming. If you have any questions, we're always here for you. Also, our 3-part newsletter series just came out in the last 3 months. Provide more information as well. Any questions, we're always here. So thank you very much. Sorry for the noise in the background, but hopefully it wasn't too bad. We'll see you next time. Thanks a lot. Thank you very much. Thank you.